bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Raise your right hand, please, sir. Solemnly swear the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Sir, yes,
Your name?
Norman Rollerson.
Mr. Rollerson, you're here today because you were arrested on a charge of open container. I've read the charging affidavit. I do find there's sufficient probable cause. Do you want to resolve that today?
Yes, sir.
Your Honor, and the offer is a withhold credit time served, and he would like to enter a plea of no contest.
All right, Mr. Rollerson, you wish to enter a plea of no contest to this charge, is that right?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol today?
No, Your Honor.
Have you suffered from or been treated for any mental illness in the past? All right, that plea form there shows you the rights you're giving up. You give up the right to proceed to trial, the right to require the state to prove their case beyond a reasonable doubt, the right to question any witnesses the state would bring to testify against you, the right to bring your own witnesses, and the right to refuse to testify or to testify based upon your constitutional rights. You understand all that? You understand that the entry of your plea could result in deportation if you're not a citizen.
Yes, sir.
It is punishable by a maximum of up to 60 days in jail and up to a $500 fine.
Yes, sir.
All right, do you find sufficient factual basis? I'll withhold adjudication. Sentence to time served,
2 days.
2 days with 2 days credit. Imposed court costs and a $10 filing reimbursement. That's a total of $233 or $233. Do you think you could pay that in the next year?
Yes, sir.
Okay.
Yes, Your Honor.
You're all set. You'll be released as to this case.
Thanks, Judge Hewitt.
Raise your right hand, please. Solemnly swear the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes?
Yes, sir.
Your name?
Jay Anderson.
All right, so you're here for Mr. Anderson. All right, Mr. Anderson, you're here today because you were arrested on a charge of aggravated battery on a pregnant person and domestic violence battery by strangulation. I have reviewed the charging affidavit. I do find that there's sufficient probable cause. There's no one here? Okay. Do you have another place to go other than 5716 Wingate Drive
Yes, sir.
to live? Where? Where can you go?
My other baby mother's house.
Okay. Because you're not going to be able to go back there or have any contact with the alleged victim in this case. You understand that?
Yes, sir.
All right. So 57 Wingate, is that where, 5716, is that where you were living before?
Yes, sir.
Is that where, let's see, Brandy was living is also?
Yes, sir.
All right. Okay. As to bond on the case, in the aggravated battery, pregnant person and set bond amount of $1,000, battery, domestic violence by strangulation, $500, and no contact with Brandy. Let me see. If I can get a last name. Say, do you have a last name for her? Wiggins, for Brandy Wiggins. No return to 5716 Wingate Drive. You can go back there one time with law enforcement. Do you have any items there? Do you have stuff there, clothes, personal items, anything?
Yes.
You do. All right. So you can return there one time with law enforcement to pick up any of that stuff, so you can go wherever you're going to go. But you have to have a separate residence from Brandy Wiggins. No contact whatsoever with her. No guns, no alcohol, no weapons, no drugs. Yeah, and that's it. And I will appoint a public defender. Here, all right, raise your hand. Solemnly swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Your name?
Grandison.
All right, is anyone here on the Grandison case? No? Yes? Someone's coming forward? Okay. All right, Ms. Grandison, you are here today because you're arrested on a charge of battery, domestic violence, let me see, yeah, they did. And then battery on a person over 65 years of age. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. All right, sir, raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Yes?
Yes.
All right, your name, sir?
Bertram Grandison.
All right, and you are one of the alleged victims in this case, is that correct?
Yes, sir.
All right. What do you want to tell me about this? Are you in fear of her, or would you not be in fear if she was able to return to the home?
I will not be fearful.
All right. I can make it, and I will make it, that she not have any hostile contact with you if she does return to the home, okay?
Yeah.
That means she can't raise her voice, she can't raise anything at you, she can't scream or cuss at you, nothing like that, okay? If she does, that's a violation of her release conditions, okay? All right. She does qualify for PTR?
She does, yeah.
All right, ma'am, I'm gonna release you, I'll give you an option. You can post a $500 bond. Actually, it would be 500, so it'd be 1,000. Or I'll release you without a bond with pretrial release conditions. Now, there are conditions you have to live up to. There's gonna be things you're gonna have to do to make sure that you're doing what you're supposed to do, okay? But you don't have to post a bond. Do you wanna do that?
Sir,
Pardon?
sorry, condition, sir, because of my unemployment status.
I'm sorry, I'm having trouble understanding.
Student and part-time, I work part-time. So, what are the conditions, the release conditions?
Well, there's a number of things. Your analysis will be one I would order. Yeah. But I mean, she can explain it to you. Or do you want to just post a bond if you don't want to worry about it?
Okay,
What do you want?
I'll do the bond, sir.
All right, so 500 on count one, 500 on count two. She can return to the home. She is to have no hostile contact with Bertram Granderson or Brittany Granderson. All right, so no hostile contact. You can't raise your voice, can't curse, can't do anything like that. Did you want to have a public defender appointed? You want a lawyer?
Yes, sir, public.
I appoint a public defender to represent you. You're not to have any drugs or alcohol, no guns or weapons. Okay? All right. Raise your right hand, please. Solemnly swear testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Your name?
Patience Henderson.
All right, Ms. Henderson, you're here today because you were arrested on a charge of domestic violence, aggravated battery, and aggravated assault with a firearm. I have reviewed the charging affidavit. I do find sufficient probable cause. Ma'am, raise your right hand, please. Solemnly swear testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, your name?
Anaya Griffin.
And you're the alleged victim in the case?
Yes.
All right. What do you want to tell me?
Well, I'm not in fear for my life.
All right, so if she were to return home with no hostile contact, you'd be okay with that?
Yes.
Where is the firearm that was allegedly involved in this?
I didn't see no firearm.
Wasn't there one, allegedly? It says Griffin stated when Henderson began arguing with her, she displayed a handgun and threatened to kill her. Did that not happen?
That's what my mom said, but I didn't say that. I was in the ambulance.
Officer says he made contact with the victim, Kenya Griffin. He says you told him that.
My mom did.
So you're saying there wasn't a gun?
I didn't see no gun.
All right. She qualifies for PTR?
She does, Your Honor.
Do you want me to set a bond in this? It would be $500 for each count, so it'd be $1,000. Or do you want to have pretrial release? So there's-
Sir, I take the bond.
all right, set the bond amount of 500 count one, 500 count two. Appoint a public defender to represent her. And so I'll allow you to return to the 1458 Mercy Drive, 218. No hostile contact whatsoever with Ms. Griffin. You understand that? It means you can't raise your voice, can't do anything, okay? She can't curse at you, she can't throw anything at you, nothing like that. You understand?
Yes.
All right. No weapons, no guns. If you have a gun in the household, it needs to be, you need to call up police or the sheriff and have them come and take it and hold on to it. All right? You can't have it in your, if you have a weapon or a gun in your house, that's gonna be a violation, okay? No alcohol and no drugs. All right, and appoint a public defender to represent you.
Naquaria Jones, behavior, Your Honor.
Yeah, I'm not surprised.
I'll waive the appearance, Your Honor.
Okay, this one is, there's a bunch.
It's 5.
So let's see, in 2022 CF 1000 AO, I have reviewed, I do find sufficient probable cause. Set bond on the aggravated battery in a pregnant person, $1,000, child abuse, $1,000, resisting an officer without violence, $500, point of public defender. In 20,
Any conditions, Your Honor, since we're here?
yeah, no, same usual, no contact at all with the alleged victim and no return to the home. No drugs, no alcohol, no guns, no weapons. In 2021 CF 13282AO, there was already, this was a probable cause warrant, stay the bonds as they were, or no, I have to set bonds. Burglary with an assault or battery, no bond. Aggravated battery on a pregnant person, $1,000. And the violation of PTR condition, no bond. Appoint a public defender on that case.
I'm sorry, yeah, which case?
2021 CF 13282AO.
It's just one charge. Aggravated battery on a pregnant person?
Okay, hold on. Actually, it's an arraignment. It says in jail arraignment 2722. But I mean, so he's out. No, this one was warrant issued 10/8. Wait, did they consolidate this one? It didn't say not to use it. Odyssey says it sets set for in jail arraignment 2722. But I don't see, there was an affidavit and a warrant was issued on 10/8/21. Information was filed 11/4. And then it says arrest affidavit 126. So my reading of that is that he was arrested on the, okay, so what you're saying, it was just the aggravated battery. All right.
You are correct, Your Honor. If you look at the actual information, it was charged as a burglary of a dwelling with an assault or battery, aggravated battery upon a pregnant person, and violation of pretrial
Right.
domestic.
So I guess what happened was there was a probable cause warrant out and it only had the one count. However, when you guys filed, you filed it as this.
Yes,
So
Your
except for an arraignment,
But that's not until.
there's no bonds on count 1 and count 3 because the original warrant only had a bond on the first.
And as count 1 is a PBL, Your Honor, I would ask that he be held no bond.
Well, here's the thing, what's my ability to do that when the warrant only had one charge and one bond, so there isn't anything for me to revoke or to do anything on, right? I mean, he was only arrested on one charge, and that's the aggravated battery with the pregnant person, according to, now I don't know if it was when the judge signed the warrant. Let me see what they sent through to him. Yeah, they only had the aggravated battery on a pregnant person on that PC warrant. So there's only the one that I can do. There's nothing to revoke. And I don't know if I have the ability at this point to set a new bond on that. Because he's not being held on that, technically. See what I mean?
I do see what you mean. I'm just trying to see.
I mean, Your Honor, if the state wants to hold him at a no bond, he still has the FTA warrant that's
Oh,
at
yeah,
no bond.
we're not there yet. That
Yeah.
ultimately, he's not going anywhere.
Yeah, he's
that's
not
for
gonna go
sure.
anywhere, so.
But I want to make sure we get this part right. I think all I can do is, in this aggravated battery on a pregnant person, set bond amount of $5,000, no contact with the alleged victim, no return to the home, have to keep separate residences, no guns, no weapons, no drugs, no alcohol. And then if the state, I think, wants to then file a motion in front of Judge Calderon, I think that they have to do that. At this point, I just don't think I have the ability to do anything since he's not under arrest on that one. Okay, then we've got 2021 CF 14258. Is that the next one? No, that's one we just dealt with, right? Yeah.
No, Your Honor, what we just dealt with was 13282.
Okay, so 14258, I think is in the same situation. Let's see, what was the warrant in that one? That is the same 3 counts. Now, in this one, the judge, the warrant that was issued was ag battery on a pregnant person and criminal mischief. What did they file? And then they added the PTR. All right, on this case then, as to count 1, aggravated battery on a pregnant person, $10,000. No contact with the alleged victim, no return to the address, must keep separate residences, no guns, no alcohol, no weapons, no drugs. And then there's no bond or anything because they added the count.
Well,
I
this-
apologize, Your Honor, what did you say for the criminal mischief? What's the bond on that?
I did not, thank you for
Oh.
pointing that out. That would be 1,000. Okay, so then we've got 2022 CF 920 AO. And another aggravated battery on a pregnant person. And there's a bond of $3,500 on that. I'll leave that one, I'll stay that bond on that warrant. No contact with the alleged victim, no return to the address, no, must keep separate residences. And no guns, no alcohol, no drugs, no weapons. And then finally, we have the failure to appear, right? On the 2021 CF 7954 AO. And on all of those counts, there is no bond. And let me see, what did they set on that? Actually, it looks like in November 10th, the judge already granted the revocation of bond. I'm not sure exactly what the failure to appear was for, but at any rate, on all the counts and that information, there'll be no bonds. Okay, does that solve all of the ills of Mr. Jones?
Yes.
Okay. Hold on. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, whole truth, and nothing but truth, so help you God.
Yes, sir.
All right, your name?
Lorraine Joseph.
All right, Ms. Joseph, you're here today because you're arrested on charge of battery on a law enforcement officer, battery, domestic violence, and petty theft. I have reviewed the charging affidavit. I do find there's sufficient probable cause on all of those charges. Now, you were living at 4761 North Pine Hills Road,
Yes, sir.
and were you living there with, I guess, Jocelyn? Is that right?
Yes, sir.
All right. Do you have another place to go? Since Jocelyn's not here, I can't let you return there.
I was actually in the process of packing my stuff up when they arrested
So
me.
you do have another address?
I was supposed to be moving out of state, sir.
Okay. All right, then what I'll do is as to count 1, battery on law enforcement officer, set bond amount of $1,000, battery, domestic violence, $500, and petty theft, $100. And I'll order that you not have any contact with Jocelyn Joseph. You're not to return to the address of 4761 North Pine Hills Road, Unit 80, except you can go there one time to get your stuff.
I can call law enforcement.
Right, you call the deputies, or you call the local police department, have them send an officer with you, you can get your personal items, and then you can move out and go to wherever you're gonna go.
Yes, sir.
And you're not to have any drugs or alcohol, no guns or weapons.
Yes, sir.
Okay, and again, no contact at all with your mother,
Yes, sir.
okay? All right. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Your name? All right, Mr. Mitchell, you're here today because you were arrested on 3 charges: aggravated assault with a firearm, 2 counts of that and 1 count of battery dating violence. I have reviewed the charging affidavit. I do find that there's sufficient probable cause. And let's see, were you living at 5443 Timberleaf Boulevard? You were not. Whose home was that?
That's the, my,
Shakara Price? All right. So you have no reason to go back there? Do you have any items or anything there that you need?
no, sir, I take, the stuff that I had there, that she had my truck.
Well, according to this, you took your truck back.
Yes.
So your truck is parked somewhere else, right? She doesn't have it anymore.
No,
So you don't have any reason to go back there.
I have stuff there, but I don't wanna go back. No reason.
All right, so, because I'll let you go, but you have to take law enforcement if you want to go to there. If you don't want to mess with it, you can just leave it.
I don't care what is there.
All right.
I don't wanna go back.
Okay, so what I'll do is I'm going to set bond in the amount of $750, count 1, $750, count 2, and $500, count 3. What happened with the, where's the firearm at?
A firearm is at my house, but,
Which house?
at 5123 Style Street.
All right. You're going to have to either give that to someone else or call law enforcement to come and have it say keeping. You're not allowed to have it.
I beg your pardon?
You're not allowed to have it while you're out on bond.
Okay.
Okay, so someone's gonna have to take that. All right, you're to have no contact with Shakara, Shakara, Price, Pryce. You're not to return to 5443 Timberlane Boulevard, number 207. You're not to have any guns or weapons, no alcohol or drugs, okay? And you have to have a separate residence. If you do have to have in contact with her, you can't return there and you can't have the same residence. Your firearm that you have must be surrendered to law enforcement or given to someone else with proof of that you don't have access to it, within 7 days of your release. Okay, did you want a public defender appointed? You want a lawyer? You want a lawyer appointed?
I need a public defense.
Do you want one appointed? I'll appoint a lawyer for you. I'll give you a lawyer.
Sir.
Okay, I'll give you one. There you go. Thank you. All right, keep in contact with the public defender. They'll let you know what's going on.
Question.
So call the number and tell them, all right?
Come on forward, sir. Raise your hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Your name?
Anthony Pittman.
Mr. Pittman, you're here today because you're arrested on 2 charges. Count 1 is neglect of a child. Count 2, battery, domestic violence. I have reviewed the charging affidavit. I do find probable cause for the battery. I have a little, it's problematic with the neglect of a child. I know that the alleged victim indicated that there was an agreement that he take care of the kids and that he came to her work. But there's nothing in the affidavit indicating that he didn't leave the children with someone else. And then by the time the officers arrived at the home, he was there and the children were there. So I don't know that there's enough to indicate that he left the kids by themselves. So I don't find probable cause on that. But I do on the battery domestic violence. On that charge, did you live at 1461 North Goldenrod?
That's our office.
What's that?
That's our office.
Okay, oh, yeah, okay, that's the accounting office, okay. Do you work there?
Yes, that's one of the places where I work.
All right, and what about, where, were you living with Aisha Tina Abdullah?
Yes. That's
All right, where were you living with her?
18 Cosmos Drive.
Okay, you're not gonna be able to go back there. You have another place to live for right now?
Yes.
Okay, where's that?
I have a cousin who's he lives on International Drive. I don't know the address right now.
All right. Okay, as to the battery, I will set a bond in the amount of $500. You're not to have any contact with Aisha, Aisha, Tina Abdullah, Abdullah. You're not to return to the Abdullah Accounting at 1461 North Goldenrod Road because she potentially will be there, so you're not to have any contact with her. You're also not to return to the home that you lived at with her. Do we have that? What was that address again?
18 Cosmos Drive.
Okay. Can't go back there for right now, all right? And I see that you guys have children together. If there is DCF involved, do we know? I didn't see that on there.
It doesn't appear so, Your Honor.
All right. As far as the children's interaction with
I
your kids?
apologize, Your Honor. Second to last line does say DCF was contacted regarding this incident.
All right, so they may have a plan. So you need to follow the DCF plan for visitation. If there isn't a plan, you have to have a third-party call about the kids. That's it. They can't call about this or anything else. They can call and say that, you know, that they're, and that you'd like to see the children, and if the children are to come see you, only supervised, okay? And you're not to go pick them up. Someone's got to bring them to you for the short term. You have to keep separate residence, again, as I said. You're not to have any guns or alcohol, no drugs, no weapons. You can go back to your home one time with law enforcement, either a deputy or a police officer, to pick up your personal items, clothes, toiletries, things such as that. Okay? As to the child, because I find no probable cause, I'll ROR him on the child neglect, but the bond and other conditions, of course, apply to the battery. All right? Did you want to have a lawyer appointed?
Yes.
I'll appoint a public defender to represent you. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Your name?
Dietrich Robbins.
All right, Mr. Robbins, you're here today because you're arrested on a charge of aggravated battery upon a pregnant person and domestic battery by strangulation. Just a second, let's see if this is the one. Oh, no. All right. Yeah, I do find that there was, oh, wait, just one second. This may have been the one. Yeah, I do find that there's probable cause for, okay, wait, there it is. All right, got it. I missed that before. All right, there is probable cause for the aggravated battery on a pregnant person, as well as the domestic violence battery by strangulation. Do you have, were you living at 1001 Nighthawk Lane?
Yes, sir, but not currently.
All right, yeah, where, do you have a place to go if you get bond?
Yes, sir.
All right, where is that going to be?
May I speak?
Mhm.
I was gonna go to my grandmother's house,
Mhm.
but in the situation, my godmother in Leesburg, Florida, she has a lawn business that she runs, and I'm supposed to start working there.
Okay,
I would like to ask, can I give her? I don't know her exact address at the moment, but
but that's where you're going to go?
yes, sir.
Okay. All right, that's the aggravated battery upon a pregnant person, set bond amount of $750.
Your Honor,
Yep,
there's a capias on this. The information has already been filed.
right,
Capias was issued January 13th.
right, it was a
Said it's
PC, it
zero.
was a PC warrant. I got to set a bond. They know bonded it. I mean, it looks like they filed it was a PC warrant because he wasn't there at the time. Deputies filed it at large, and then it went, you guys sent it over and the judge signed it. It wasn't because he failed to appear.
Okay.
So I will set bond amount of $750 on the battery on an aggravated battery upon a pregnant person, and $500 on domestic battery by strangulation. You're not to have any contact. Hold on, I clicked out. Wrong thing. Hang on. no contact with Ashari. They ever put their name in here fully?
White?
Is it White?
Yes.
All right, Ashari White. No return to 1001 Nighthawk Lane. You can go there with law enforcement one time to pick up any items that you may need, any personal items, toiletries, things such as that, okay? But that's it. You're not allowed to have any, you have to have a separate residence with Ms. White, and no drugs, no alcohol, no guns, no weapons. Okay?
Yes, Your Honor.
You want to have a lawyer appointed?
I think I'm gonna have one.
You want a public defender?
Yes.
All right, I'll appoint a public defender to represent you. All right, your name, ma'am?
Sarah Linda Teresa Torres.
All right, raise your right hand, please. Solemnly swear the testimony you're about to give you the truth, the whole truth, and nothing but the truth to help you God.
Yes.
All right. Ma'am, you're here today, you're arrested on 3 charges: attempted second-degree murder, aggravated battery with a deadly weapon, domestic violence, and battery domestic violence. I have read the charging affidavit. I do find sufficient probable cause. There'll be no bond on count 1, attempted second-degree murder. Aggravated battery with a deadly weapon would be $1,500, and the battery domestic violence, $500. And you're not to, were you living at 1628 Yvonne Street?
Yeah.
That's what, it was like it's someplace behind that address or something, it sounded like?
Yeah, it's like got its own entrance.
Okay.
You know what I mean? Yeah.
You can't return there at this point in time. If you do somehow acquire release, you're not to return to that address. You're not to have any contact with Patrick Joseph Cahoon, K-A-H-O-U-N, Jr. You cannot possess any drugs or alcohol, any guns or weapons. And I'll appoint a public defender to represent you.
And Your Honor, I believe count 1 is not a punishable by life offense. I believe she's entitled to a bond.
All right, I'll set bond an amount of $25,000.
Sign right here.
Raise your right hand, please. Solemnly swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Your name, sir? All right, Mr. Williams, you're here today because you're arrested on 2 charges: battery, domestic violence by strangulation, and battery, domestic violence. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. Were you living at 429 Jernigan Avenue?
Yes, sir.
And was the alleged victim, Angel Geese, also living there?
Yes, sir.
All right, so she will be at that address, assuming if you got out. So you can't go back there, all right? Do you have another place to go?
Yes, sir.
Where's that?
My sister's house.
Okay. All right, as to count 1, battery, domestic violence by strangulation, of set bond amount of $750, battery, domestic violence, $500. You're not to return to 429 Jernigan Avenue. You can go back there one time with law enforcement to get any personal items you may need. All right, but you have to maintain a separate residence and have no contact with Angel Dees, D-E-A-S. All right, you can't have any contact with her whatsoever. All right, not to possess any drugs or alcohol, no guns or weapons. And did you want to have a public defender appointed to represent you? I'll appoint a public defender. Keep in contact with your lawyer.
750 and 500.
Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
I swear.
All right, your name, sir?
Emmanuel Chapman.
All right, Mr. Chapman, you're here today because you're arrested on a charge of battery. I have read the charging affidavit. I do find that there is sufficient probable cause. Let's see. Now, were you living at 6451 Westwood?
Yes.
And does the alleged victim live there as well?
Yes, but I believe she moved last night.
That's Andrea Killius? All right. Okay, well, what I will do is, I will say that you cannot return there if she is there. Okay, now, that puts you in a precarious position. If you're not sure, if you bond out, what I would do if I were you is have someone else go and see if she's there.
Okay,
If she's there, you can't go there.
okay,
If she's not and has moved out, you can,
okay.
all right? But you're not to have any contact with Andrea Traquel, Traquel, Killius, last name Killius. No contact with her whatsoever, okay? No guns, no weapons, no drugs, no alcohol. And I'll step on, actually, he qualifies for PTR?
He does, Your Honor.
All right, do you want to have a bond, or do you want to be released without a bond with pretrial release?
I was hoping to be released without a bond.
All right, I'll release you pretrial release, so there's no bond. You're gonna have to sign a contract with them, okay?
Thank you, Your Honor.
All right, do you want to have a public defender appointed to represent you?
Yes, please.
All right, appoint a public defender to represent you.
Appreciate it. Thank you. Okay, thank you.
Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God. Your name? All right, Mr. Cummings, you're here today because you're arrested on battery, domestic violence. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. You were living at 2701 East Colonial, correct?
Yeah, it was my
Yeah, and Mr. Yoho was living there also?
he was staying with me on the terms that he would pay rent, and he wasn't paying rent.
Is he, do you know, is he still there?
I had, before I called the police, I'm the one who called, I went to the office and had him removed off the lease, which is when we started arguing, and then he headbutted me.
All right, well, here's the thing. You're gonna be in the same situation. I'll allow you to return to 2701 East Colonial Drive if he's not there. If he's still there, you can't go, even though, unless and until they evict him or throw him out, you can't be there if he's there, because you can't have contact with him.
As far as I know, the police were having him take his stuff, he was already packing up.
Could be, but what I'm telling you is that he doesn't have an order of the court, you do. So if you go there and he's there, you're gonna be the one in violation, not him, okay? So it's important that you make sure that that's not the case. If I were you and I had a friend, I would call someone and say, hey, can you go to the house and make sure he's not there, all right? Because I'm gonna order that you have no contact whatsoever with Andrew Yoho, Y-O-H-O.
Andrew, my name's Andrew, his name is Jeremy Yoho.
All right, well, we'll change that to Andrew or Jeremy Yoho, all right? It was probably a typo. But no contact at all with him? None, zero, okay? And you'll be allowed to return to 2701 East Colonial Drive if Mr. Yoho is not present. If he is, you cannot reside there. You have to keep separate residences, can't live together, okay? You can't possess any drugs or alcohol, no guns or weapons. And he does qualify for pretrial release.
He does, Your
I
Honor.
can either release you pretrial release so there's not a bond required, there are conditions, or I'll just set the bond at 500 and you gotta post the bond.
What does that mean? What pre-trial mean I can get out today?
Well, both you can. If you post the bond of $500, you can get out. But pretrial release, they'll talk to you, they'll tell you what your conditions are, then you get released.
Whichever will be the fastest, I have work tomorrow.
I don't know what's gonna be the fastest. It's up to you.
Sorry.
He said he would do the pretrial.
All right, pretrial, I'll release a pretrial release then. Did you wanna have a public defender appointed? Do you need a lawyer? No. No? All right, you gonna hire your own? Okay, you're all set. All right, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Sir,
All right, your name, ma'am?
Nicole Graham.
All right, Ms. Graham, we're here today because you're arrested on a charge of battery, domestic violence. I have reviewed the charging affidavit. I do find that there's sufficient probable cause for that. Were you living with Willie Russell at 1934 McCoy Road?
Yes,
Okay, and he's not here. Do you have another place to go?
I live in Tampa, home.
Okay, so you don't have any reason to have to go back there?
No, sir.
Okay. All right, then, what I will do is I'll set bond the amount of $500. I will order that you have no contact with Mr. Willie Russaw, and that's R-U-S-S-A-W, all right, no contact at all.
We have a child together, so.
I understand that, but for right now, you can't have contact with him. If there's something that you need to deal with your child, do you have any relatives or anyone else who live in town? They can contact him The only thing they can contact him about, though, is the child. They don't want to mention anything about the case or anything, because that'll be a violation of your bond, okay?
Yes, sir.
But no contact, Mr. Russell. You're not to return to 1934 McCoy Road, number 227. However, you can go back one time with law enforcement, whether it's a deputy or a police officer, to pick up any personal items, clothing, toiletries, such as that. No furniture or TVs, which you can pick up other stuff, okay?
Sir.
Again, no contact now. It might be at some point that they can change that to no hostile contact, but for right now, no contact, Mr. Russell. Okay? Any questions? All right. I will appoint a public defender to represent you. All righty.
Your Honor, can we at least do no drugs, no alcohol?
Yes. No drugs, no alcohol, no guns, no weapons. All righty. Your name, sir?
Mr. Care.
All right, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. All right. You're here today because you were arrested on charge of battery, domestic violence. I have reviewed, actually, it looks like it was I have reviewed the charging affidavit, although it was a PC warrant. And let me get that information. Were you living at 1885 Jewel Ave? All right, and you were living there with Deja Stovall? All right. Do you have another place to go?
Yes, sir.
Where's that?
18 West House Street.
And whose house is that?
Granite.
All right. Okay, I will set bond. Actually, you do qualify for pretrial release as well. I can either release you with pretrial release conditions, or I can just set bond an amount of $500. I can set bond at $500, or I can release you with pretrial release conditions if you want that. Bond, all right, $500 bond. Conditions will be that you not possess any drugs or alcohol, no guns, no weapons. You're not to have any contact whatsoever with Deja, D-E-J-A-H, Stovall, S-T-O-V-E-A-L-L. You're not to return to 1885 Jewel Avenue, apartment 274, except you can go there one time with law enforcement to pick up any personal items that you may have, okay? Maintain separate residence if she does move to somewhere else. You can't live with her for the time being. Did you want to have a lawyer appointed?
Yeah, I'm gonna get one.
You're gonna hire one? All right, then, I want to appoint a public defender at this time. All righty. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, all right. Your name?
Jasmine Nunez.
All right, Ms. Nunez, you're here today because you were arrested on a charge of battery, domestic violence. I have read the charging affidavit, and I do find that there is sufficient probable cause. Sir, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Your
Yes.
name? Your name is?
Edgardo Garcia.
All right, and you are the alleged victim in the case? Is that right?
That's what they're saying.
All right. And by that, do I take it that if I were to set a bond for her and have a condition of no hostile contact, you would not object to that?
I don't want no contact order in there to begin with. I don't even know why any of this even happened.
Well, the allegation is that the officer was investigating, I think, a traffic accident, and that he witnessed your, I guess, wife batter you.
Yeah, he was still pulling up on that, while he was just pulling up, and she was just mad about the whole accident. So by the time he was even getting out his car, she was just upset, and she expressed it like,
Okay.
"Man, babe, I got into this."
I understand. So what I kind of hear you saying is that he couldn't have seen her batter you because the battery happened before he got there.
No
But regardless, you don't have a problem with her returning home, is what you're saying?
Absolutely not.
All right. Does she qualify PTR? Ma'am, would you rather me set a $500 bond, or would you like pretrial release so that there isn't a bond required?
Me?
Yeah.
Pre-trial release, does that mean
You
I
think she
don't?
would qualify? You guys are living at a hotel, or do you have a residence?
Can we do
Nope.
the bond or, Your Honor, because she didn't initially qualify?
All right. What I'll do is I'll set bond in the amount of $500. If you do qualify, they're going to relook at it. If you do qualify, I'll allow you to be released PTR, so there won't be a bond required.
Yeah, because I don't have anything right now, honestly.
Okay, well, they'll check and see. And no hostile contact with your husband. That means she can't raise her voice to you, can't raise her hands to you, nothing like that. She can't put her hands on you.
He never did.
I understand that. I understand that's your position. I'm telling you that that's the condition, okay? She's not to possess any drugs or alcohol, no guns or weapons. And the 441 South Highland Avenue, that was where the accident was?
Correct.
Okay. Well, you guys can live together as long as she's not hostile to you, all right? Okay, and I'll appoint a lawyer for you. I'll appoint the public defender.
Excuse me, Your Honor.
Yep. Yeah, go
When
ahead.
would I find out if she qualifies for the PTR?
They'll give you a call.
They'll call you,
Okay.
okay? All righty.
So I just have to wait for that?
Mm-hmm.
Okay.
It'll be today. They'll get to you. They're good. They're quick. Okay.
They'll let you know.
They're gonna come see you. Yep. Okay. All right. Raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God? Okay, who is this? Oh, all right, ma'am, your name?
Samaya Burton.
Ma'am, you're here today. Let's see. No. Where's this one? Because you're arrested on a warrant out of county. I don't have it.
Mm.
All right. Ms. Burton, you were arrested on a warrant out of county. It looks like it's from Jacksonville. Is that right, Duval? Because it's, Seminole County. The bond is in the amount of $263. And does she got, is there any holds here?
No, Your Honor.
All right, so either you can bond out for the 263 or at some point, Seminole County will come and get you.
How long did they have to come get me?
Usually we will contact them right away within a couple of days. All right? There you go. I'll keep these so you don't get messed up. All right, raise your right hand, please. Solemnly swear a testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Your name, sir? All right, Mr. Harley, you're here on a warrant for violation of probation and grand theft out of Polk County, and there is no bond on that. Polk County will be notified.
We want our handle behavior, Your Honor.
All right. Oh, she's being held on $500, and no bond in Seminole County. So just stay those.
So over the line arrest.
Yeah.
As far as the aggravated assault, based on this arrest affidavit, Your Honor, it does not appear, it appears that there was damage done to the vehicle, but it does not appear that there was a threat or anything made in the presence of the victim, based on my reading of this arrest.
He said that in the text messages that she would show up to her house, throw acid on her cars, and she would bring a group of people to fight her.
Yes, Your Honor, it was via text message. There was a written threat to kill, an aggravated assault, as that threat was not, it does not appear received.
By word, threat, or deed, with the ability to carry it out within a reasonable amount of time. It's well-founded fear. I think it's sufficient. Word, act, or deed, I guess is the actual thing. So, all right. Rogers?
Akaya, lawyer, medical.
All right. I'll stay the bonds on those as well. I do find there's probable cause, so there's, I mean, it doesn't matter, some of the counties. Okay, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes? You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Your name?
Ezra Williams.
All right, Ms. Williams, you're here because you are being held on 2 out-of-county warrants from Lake County. And there's bonds on those, $2,000 on each count. Okay? And Lake County will be made aware of the fact that you're here.
I ain't never been to Lake County.
Well, Lake County loves you because they got 2 warrants for you. They'll figure that out. It looked like it was for uttering a forgery, might have been check cases. So it's possible that you, I don't have really enough information. Yeah, uttering a forged check and grand theft 3rd degree more than $300, but less than $20K. Angela Nicole Williams, date of birth 8/9/81. It's a 2018 case, felony case. So it was a while ago. Okay? They'll get it sorted out. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, your name, sir?
Brian Young.
All right, Mr. Young, you're being held today on a warrant from Volusia County for a trespass, and the bond is $2,500. And they'll be made aware that you're here, and if you can't bond out from here, or they'll come and get you eventually. Okay? All righty, good luck. They're not going to get a phone call from somebody here, but, well, they may check to see if you're not there and say, well, you're in jail here. Obviously, at some point, if they do try to violate you for that, then the fact that you're here.
It was yesterday when I went to court for it, and I was ordered to go visit with them today.
Probably, honestly, we're not going to call them. I mean, it just doesn't happen. So you're going to have to either try to get someone to do that for you or just wait. And then when you resolve this or get to Volusia County, you can let them know. Okay? All right, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Your name, sir?
German Bias.
Hang on just a second. I'm a little behind. There we go. All right, Mr. Bias, you're here today because you were arrested on several charges. Or excuse me, it was for a violation of probation.
Yes, sir.
And there is no bond on that. Do you want to have a public defender appointed to represent you on the violation?
Yes, sir.
I appoint a public defender to represent you. Your name, sir? Oh, excuse me. Raise your right hand. Solemnly swear a testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right. Your name, sir?
Brandon Sanchez Brinson.
All right. You are here today because you were arrested on a violation of probation, and currently there is no bond set on that as well. Did you want to have a public defender appointed?
Yes.
All right. And I see, I guess there's some, I don't know, it looks like there was an appeal sort of going on. I don't know what happened with that, but on the violation, then I will appoint a public defender for you on that. Okay? Raise your right hand, please. Solemnly swear a testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right. And your name, sir?
Robert Lucas Luciano.
All right, sir. Let's see. So you have, and I think Blair Jackson is representing you on one of these. Is that right?
Blair Jackson is representing me for the original charge that I violated for.
And that's the one they're here for today.
So what exact charge am I?
Let me just take a look real quick. Actually, it looks like is this an arraignment?
No, Your Honor.
for the violation?
He has a on-view VOP, and he has a trespassing charge.
All right, so this is just for the on-site, for basically amending it, because he was already violated end of the last year, 12/28. So there was a violation of probation pending already. So they added on the new charge, right? Is that in essence what happened there?
I'm sorry?
Well, he was already violated. 12/28, there was a violation of probation, I assume probably for technicals or for other stuff. Then he got this new charge, the trespass charge, and so the onsite would be because they're, in essence, amending that original violation of probation then, right?
What?
Am I correct in that
I have a
assumption?
recollection of the VOP from, you say December?
Yeah, 12/28
Yeah, we don't
according
have
to
that.
Odyssey.
I believe they arrested him on the trespass, and then they did the on-view due to the new charge of the trespassing.
Right, I understand that. What I'm saying is that he was already out on bond for the violation because the violation's set in I think next week. So he must have been out on bond or out on some release condition.
I found it out about 3 weeks ago.
Right.
I paid $700 to find out.
Let me see. So the onsite is just really technically not a violation, it's a amendment to the violation. You bonded on a $5,000 bond on that. All right, this is what I'm gonna do. As to the violation, the onsite, I'm not gonna take any action on that. He's already on bond on that for $5,000. I'm not gonna deal with the bond. And then on the trespass, that is a new charge. And I have reviewed that, and I do find that there's sufficient probable cause on that. I set bond in the amount of $250. Okay?
Are you gonna take any action on his out on bond case?
And that's the VOP though, right?
No. That's a whole totally new case that he got arrested on, like he said, a couple of weeks ago.
Your Honor, if you read the bottom of the trespass, it does explain what happened. So it appears as though a defendant had a VOP. It was based on the arrest for the grand theft, but there was also a positive drug test, and then he also got arrested on the trespass.
Right, I understand that. The violation, though, was already in place. He bonded out on the violation. The violation was the hot urine and the grand theft. The violation is, I have on here. The grand theft, I don't have on Odyssey, so they didn't give me that one, but I see what you're saying now. The violation, though, the onsite for the trespass is merely just amending it to add that. So now he's got a grand theft, he's got the new charge for the trespass and the other thing. He already had been arrested, and that was already in process. Because if you look at Odyssey, it's clear. So, but he's out on bond then on the grand theft, which is part of that violation, right?
Yes. The grand theft is 21 CF 15932.
Okay, as to the, grand theft, I will revoke the bond of $1,000 and, set a new bond of 2,500.
Which case number we talking about?
2021 CF 15932AO.
Are you gonna revoke?
And set a new bond of 2,500.
What about 9520?
9520, that's the violation of probation one? Oh, no, yeah, I'm not gonna, I'm gonna leave that in place. Yeah, he's already,
He's having no bond right now, so you gotta release him on.
we already filed, he was already out on bond on that. So how is he detained? Nobody ordered that, that just came through, but there was on-site, so I guess I could. Ridiculous. Well, then obviously at some point, somebody then, I'll just, his bond wasn't forfeited, was it? Couldn't have been on the on-site, right?
No, it wasn't.
So they were just detaining him, so I'll just release that because his bond is still in place.
The officer did an on-view because he was.
Because he got a trespass.
Correct. So as to this charge, as to the on-view VLP, what do you do with it? You want to put it on bond?
Well, but I mean, that's what I'm saying. There's a detainer on him, but his bond was not forfeited, so the bond is still in place. I'll just remove the detainer. He's bonded on that charge.
He's bonded under 15932. And this is a separate charge, the on-view that the officer did.
Under 2020 CF 9520 AO, they filed, it's an amended violation of probation. It's not a new violation of probation. He already was violated on his probation. That's what I was saying from the very beginning. It's not it's not a new violation, it's an amendment. Because he had already bonded out on 12/30/21 for the violation of probation. There was he got arrested. It looks like he was at first appearance on 12/28/21 for that violation of when they on-cited him then. And then they set a bond for it for $5,000. He bonded out, so the violation was already happening. When he got arrested for the new thing, they did an on-site, but that just detains him so that he can be held here. He's bonded, so the bond is not forfeited, it's still in place.
Okay, so only thing I'm asking is the clerk, what do you want me to do as far as the order on this particular charge? You wanna leave it at place, but right now say in place is a no bond.
But that's okay, then I'll set bond an amount of $5,000, and he's posted a $5,000 bond, right? Well, I mean,
Your Honor,
it's right there, he posted a $5,000 bond, it's in the computer.
Yeah, we understand that, Your Honor, of what the officer stated about, they mentioned they doing a VOP because it's stemming from the incidents he previously was on bond for, which is the out on bond
Right,
case.
that's not, I understand why they did what they did. However, it's not a new violation. He's already been violated. In other words, once the judge signed that first violation, it's a violation. Anything that comes after that, until that case has been cleared up, whether they found the violation and they've been sentenced, revoked and terminated, put on a new term, or whatever, it's an amendment. It's not a new violation of probation. Because as it stands, he's in a violation status. So what should happen is the paper would come through the judge would sign the amendment, and either, if they want to, they can put another warrant out for it. Generally speaking, it just comes through and it gets added in to the original violation of probation warrant.
Understand. So with this charge is what she's saying, are you gonna release it ROR?
No, I don't, I mean, there should be no reason for that because his bond is still in place. Okay, in other words, when that paperwork came in, by administrative rule, whatever, he's detained. But he has posted a $5,000 bond. It has not been forfeited. It's still there. There's no order from a judge forfeiting that bond, right? He posted a bond on the violation. It shouldn't have been a detention from the start. What it should have been was, okay, you got arrested. I'm going to amend that original violation. That's where the screw up was. Should never have been that. Once she or she's already violated him and something else comes up, it's not a new violation. It should have then been just an amendment and a request to, for the other charges that he's out on bond on, I see. But that doesn't apply here.
So you want me to put court take no action, bond remain at 5,000?
Yeah, I mean, I guess. I assume, yeah.
Okay.
I don't want to ROR him because he's got a bond. I mean, he does have a bond there.
A bond.
But I think, I mean, if we do it this way, we have to post another $5,000.
No, he has a $5,000 bond. If I set bond at 5,000 in this case, it'll show that it's already there.
Okay, that's all.
I think it should revert back. Well, where's it gonna go?
It was a new affidavit that they did. That's what the clerk was trying to say. It's a new affidavit as a new charge because of the trespassing. And they put that at no bond.
I think it got messed up, Your Honor.
No, it's totally messed up. It should not have been done this way. This is not proper. It's not. It shouldn't have been done this way. Because I mean, it doesn't even, because they don't relate in here that he was already in a violation status. That's what should happen.
In the arrest affidavit, the officer actually says the defendant was pending violation already.
Right. So they should have known that. See, it says right there, probation, so on-view violation of probation stemming from the incidents previously mentioned that he was allowed bond for. They knew it.
I think the issue, I don't want him to just sit here.
No, I agree. I mean, if it was, and let's be honest with you, what part of my consternation is, he walked by and was close to a lift pump station that had a no trespassing sign, and that's what resulted in all this whole thing. It's ridiculous. It's ridiculous. My guess is this case isn't going to get filed on. I'd be surprised. You know what? Just ROR him then. Forget it. It's messed up. They shouldn't do it that way, but that way for sure it's not going to be a problem. So he's got a $5,000 bond. I guess the bondsman will get notice he's ROR'd, and then they can come off their bond.
Is he gonna get his own attorney on these?
Yeah, did you want a public defender, or are you going to hire Blair on these? Okay.
All right, thank you.
Your name, sir?
Jacob McMurphy.
Not on Odyssey. All right, Mr. Murphy, you're here today because you're arrested on a violation of probation for the scheme to defraud and grant theft third-degree charges that you were placed on probation for. It's like in 2017. There is no bond. Did you want a public defender appointed to represent you on those?
Yes, sir.
All right, I will appoint a public defender to represent you.
Is there, was there a reason for the violation?
Yes, you're set for, actually, it says today. So Is that what it's supposed to be?
Then I wasn't charged with anything.
That's in jail arraignment, 127.
Tomorrow.
Oh, is that tomorrow? Judge McDonald will handle that for you. What happens, you stay in the jail too much, you lose track of your days. Yeah, you'll be brought back tomorrow for that. Okay? And the public defender has been appointed, so they'll be here for you.
Thank you.
Uh-huh. Raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Your name?
Just the truth.
Your name?
My name is Juan Carlos Morales Cavazos.
All right. Second. You are also here for a violation of probation. There's no bond for that. This is an accessory after the fact of a capital felony. And again, there's no bond. Did you want to have a public defender appointed to represent you? Want a lawyer?
I have no lawyer.
Do you want a lawyer?
Yes, sir.
I'll appoint a public defender for you. Also set tomorrow.
Thank you.
All righty. Raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, and your name is? All right, Ms. Paul, you're here today because you were arrested on a violation of probation. Let me make sure one of these did bond. Yeah, currently there's no bond on that. Did you want to, that was from a charge of fraudulent use of a credit card from 2019. Did you want to have a public defender appointed to represent you?
I'm sorry, I have a private attorney.
You're gonna have a private lawyer? Okay, good luck. All right, raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Sir.
Your name?
Gian Soto Claudio, sir.
All right, sir, you're here today because you're arrested on a violation of probation. And there is currently no bond on that. Did you want to have a public defender appointed to represent you?
Yes, sir.
This is on a number of charges out of, looks like 2015, 2016, something like that. I will appoint a public defender to represent you.
Thank you, sir.
Mhm. Okay, you raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, your name, sir?
It was Fernando Ibanez.
All right. You were here with us yesterday, weren't you?
Yes, sir.
Are you gonna, was it Blair Jackson that was representing you?
Yes, sir.
All right, so you're gonna be representing you on this case, on the violation of probation?
Yes, sir.
All right. Let me get to it real quick. All right, this is from a DUI, violation of probation. Let me see what they did. And currently, there's no bond on that. So you're all set, okay? And see, that's the difference. All those last VOPs, they hadn't been arrested before. So that's the difference. That's an actual warrant. All right, 33 days. Anquavius DeMarcus Preston, 2021 CF 16091AO.
Granted, notice of non-filing.
Nikita Lachey Ward, 2021 CF 16147AO.
Denied, information was filed.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Good morning, Your Honor. I'm Mr. Mayor, certified federal interpreter, already sworn. 1 second while I connect to the headphone.
Alrighty.
The interpreter is connected, Your Honor.
All right, sir. Your name?
Por favor, señor.
Raulito Balmoris Westby. Westby.
Raulito Balmari Wesley.
All right, raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Sí.
Yes.
All right, Mr. Westby, you're here today because you're arrested on a charge of no valid driver's license. I have checked or read the charging affidavit. I do find that there's sufficient probable cause. Is there a possible plea in this case?
Yes, Your Honor. It's an adjudication of guilt, credit time served. I did speak to Mr. Westby. I went over the immigration issue, and he still would like to accept the state's offer and enter a plea of no contest.
Okay. All right, Mr. Westby, so your attorney indicates you wish to enter a plea of no contest then to the charge of no valid driver's license. Is that correct?
Sí.
Yes.
Are you under the influence of any drugs or alcohol today?
No.
No.
Have you suffered from or been treated for any mental illness in the past?
No.
No.
All right, the plea form that I've been handing indicates you have certain rights. You understand you're giving up those rights by entering your plea of no contest today.
Sí.
Yes.
Do you have any questions about anything on this form?
No.
No.
Now, you understand that this is punishable by up to a maximum of 60 days in jail, up to a $500 fine, and that the entry of your plea could be used against you in any deportation proceeding if you are not a citizen.
Sí.
Yes.
All right, I do find a sufficient factual basis to accept your plea and will adjudge you guilty of the charge of no valid driver's license. You're sentenced to time served, which is 2 days, and you do have 2 days credit for time served. I will impose court costs and a $50 cost of prosecution. It's a total of $306. If you want to pay for that, can you pay for that over the next 12 months at some point?
And Your Honor, can you also advise him to have some immigration help?
Yep, I will. Can you pay for that in the next year at some point?
Sí.
Yes.
Okay. Now, the only other thing I need to let you know is that you do have a hold for immigration. They will decide whether they are going to proceed with that or not, but they'll keep you posted. And any more Spanish? That's it? That's it? No Spanish?
Your Honor, I need the case number. Sorry.
Sure. That was 2020, hold on, 2020 CT 6578AO.
Thank you, Your Honor.
And that's it. Thank you.
You're welcome. Have a good day.
You too. Bye-bye. All right. So Cardonas.
It's behavior, Your Honor.
Trying to reset them.
I'll waive these here, Your Honor.
Okay. Let me get him up here. All right, on the battery charge, set bond in the amount of $500, the trespass $150. Defendant is not to return to 5590 West Oak Ridge Road. And he's had to have any contact with Angel Williams. No guns, no weapons, no drugs, no alcohol. And that's a mobile gas station at 590 West Oak Ridge Road. It's not to return. And I'll appoint a public defender, if not previously done so. All right, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Your name?
Stacey Patrice McCullough.
All right, Ms. McCullough, you're here today because you were arrested on a charge of petty theft. I have reviewed the charging affidavit, and it does appear that there's sufficient probable cause. Bond set in the amount of $500 on that. And currently you are out on bond on a driving while license suspended. I'll take no action on that. I'll leave that in place. Did you want to have a public defender appointed on the petty theft?
I thought I have a public defender already. I just want to know if there anywhere I could be released on R&R.
No. You were out on bond already and and allegedly committed another offense. No ROR. So, but I'm not going to revoke your bond on the driving while suspended. So I'll give you that. But I'll appoint a public defender to represent you then on the new charge as well.
Battle, Your Honor, refuse.
Okay. Okay, as to the burglary of a conveyance. Yeah. You find sufficient probable cause, stay bond in an amount of $3,500, appoint a public defender. And as to the 2021 CF 2548AO, I revoke that bond, no bond. Timrell Battle. Yeah, he refused. And then in 2022, CF 978AO. I'll stay the bonds as they were initially placed on him and appoint a public defender to represent him on that charges, on those charges as well.
And you said you were revoking his out on bond, Your Honor?
Yeah, on the one that he was out on.
Okay, thank you.
And then the rest will just stay the bonds that were there. All right, sir. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
All right, your name?
Yes, Your Honor.
Your name?
Scott Bradley Webb.
What was his name? What was your name, sir? I'm sorry.
Arraignments.
Oh, okay. That was, this was the Wilberson was one of the ones we're waiting on. Okay. Let me find Webb. Okay, we got you. All right, Mr. Webb, you're here for arraignment on your disorderly conduct charge. And is there an offer in the case?
There is, however, Mr. Webb would like to enter a plea of not guilty.
Okay. Well, we've already done that, so we'll set that for pretrial. That'll be in Division 85.
Pre-trial conference will be February 21st
And,
at 9 a.m., courtroom 4A.
all righty. There you go. Thank you, sir. We have Madeline Santana, Bradley Villegas, or Corey Wilson. Those are the other three I had as arraignments. All right, raise your hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes?
Yes.
All right, your name?
Charles Robertson.
What's the first name? Back to the other one, okay. That's all right. All right, Mr. Wilberson, let me get your file here. There we go. You're here today because you were arrested on a arrest warrant for petty theft with 2 prior convictions. I have reviewed that, and the bond is set at $1,000. Did you want to have a public defender appointed to represent you?
Yes.
All right, I'll appoint a public defender to represent you. All right, she's going to give you some information. All right, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Sir.
Your name?
Corey Wilson.
All right, Mr. Wilson, you're here for arraignment on your criminal mischief charge. We'll set that for a pretrial in Division 62. And you already have a public defender appointed, so keep in contact with your lawyer. And that will be?
March 7th.
March 7th?
At PM, courtroom 12C.
Okay, you're all set.
You sure I don't got no bond?
There already is a bond on there, isn't there?
I don't got no bond? No. Your Honor, in direction, Santana Madeline is medical.
Okay, and, public defender, do you want to just go ahead and set it for pretrial? Set that division, Madeline Santana for pretrial division 85.
February 21st, 9 a.m., courtroom 4A.
And Brandy Villegas.
Villegas is, medical also, Your Honor.
All right, set that for pretrial division 61.
February 25th, 1:30 p.m., courtroom 6B.
All right, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
Your name, sir?
James Christian.
Hi, Mr. Christian, you're here today because you're arrested on a charge of battery. I have reviewed the charging affidavit. There is sufficient probable cause. A set bond amount of $500 with the conditions also that you have no contact with Aramis Bermuda. Oh, no, excuse me, that's the wrong person. No, I guess it is. Aramis Bermudez, yes. They have no contact with him. Were you living at 1301 North Powers Drive?
Yes, sir.
And is that where Aramis Bermudez lives?
Yeah, we were roommates.
All right. Well, if he is there, you cannot return there for the, at least on the time being. You should not have any contact with him. So you will have to have a separate residence from Mr. Bermudez. No guns, no weapons, no drugs, or no alcohol. Okay? And did you want a public defender appointed? Want a lawyer?
Me?
Yeah.
Do I want a public defender or lawyer?
Yeah, you want a lawyer? I'll appoint a lawyer if you want one.
Yeah, a
All
public.
right, appoint a lawyer. Did you have a question? Did you have a question? You were going to say something.
We were in the same room together in the rooming house, so I would have to get my stuff out.
You can go back there. You can go to the rooming house at one time with law enforcement. So I'll allow you to do that. You can go back there, call the sheriff or get with the local police and get them to come with you one time, and you can take your stuff out. If he's not there, if he's moved out,
Yeah.
because if I don't know if I've seen him, but it looks like they say he's a defendant too. If he's not there, you can stay there, but you can't be there if he's there.
Yeah.
Okay, so I'll put that in there, that if he has moved out, you can move back in.
Yeah, but you
Okay.
haven't seen him yet, so I'm
Right,
gonna be there first.
right, you'll be first. Okay?
No.
All right,
Antonio Hopkins, refused, Your Honor.
all right, let's see, waive.
Yes, I'll waive, Your Honor. There's conflict.
Okay, I did find probable cause, set $500 and no return. And then on the battery charge, revoke the bond, no bond. And then you can figure out whatever goes on with that. All right, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes? All right, your name? Your name, sir? Your name? What's your name? All right, Mr. Jamison, you're here today because you're arrested on a charge of criminal mischief. I have reviewed the charging affidavit, and there is sufficient probable cause. I will bond a set in the amount of $500. If you do bond out, you're not to have any contact with Karen, first of all, Clarissa Standing Bear, or Karen Ganaway, Ganaway, to spell the last name, and Clarissa is Clarissa, and Standing Bear, just as it sounds, Standingbear. And you're not to return to 805 Ferndale Road either. So no contact with those two individuals, no return to that place. Did you want to have a public defender appointed to represent you? You want a lawyer?
I think he has trouble
Yeah,
hearing.
can he not?
Do you want to have a lawyer appointed? Can you hear me?
I think he needs a hearing device.
Need what?
Do you want a lawyer?
Yes.
You can whisper, you can hear that. You can't hear me yelling at him?
He said, yes, Your Honor.
Okay, I'll appoint a public defender to represent you. He walks up and whispers to him, you can hear that, but I'm screaming at Name, sir?
Nicholas Wachek.
All right, raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. All right, you're here today because you're arrested on a charge of trespass to a structure or conveyance and resisting without violence. I did find that there's a sufficient probable cause. The bonds that are set are $500 on the trespass, $100 on the resisting. Did you wish to have a lawyer appointed?
You're good now. Your Honor, the offer is an adjudication of guilt, credit time served, and no return to the McDonald's located at 2701 East Colonial Drive. Mr. Witchick would like to accept and enter a plea of no contest.
Okay, is that correct, Mr. Wachek? You want to resolve your case? All right, are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No.
This plea form I got here with your signature, you understood all the rights of that and signed it on the bottom?
I do.
Any questions about the rights on that form?
None whatsoever.
Understand that, it's punishable by up to a year in the county jail, up to $1,000 fine, and that the entry of your plea could be used against you in any deportation proceeding that may be brought if you're not a citizen.
I understand.
All right, I do find sufficient factual basis. I will adjudge, it's on both counts, right?
Yes, Your Honor.
Will adjudge you guilty of count 1, trespass, structure, or conveyance, count 2, resisting an officer without violence. You'll be sentenced to time served.
2 days.
2 days with 2 days credit for time served. Those sentences will run concurrent with one another. I'll impose court costs and a $50 cost of prosecution, which is a total of $273. Will you be able to pay that over the next year?
Yes, sir.
All right, pay that within a year. And finally, I'm going to order that you not return to the McDonald's at 2701 East Colonial in Orlando. If you do return there and the court's made aware of that, you are subject to a contempt citation, which could result in a jail sentence of up to 180 days in the county jail. Thank you. You'll be released as to this case.
Thank you.
Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Your name?
Cedric Desmond Barron II.
All right, Mr. Barron, you're here today because you failed to appear on your petty theft charge, and the bond on that failure to appear warrant was $1,500.
And Your Honor, the offer is an adjudication of guilt, credit time served, and no return to the Walmart located at 8101 South John Young Parkway. Mr. Barron would like to accept the offer and enter a plea of no contest.
All right, is that correct, Mr. Barron? You want to enter a plea of no contest to this petty theft?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
Did you read over your plea form, understand the rights, and sign it on the bottom?
Yes, sir.
Any questions about the rights on the form?
No, sir.
Understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Yes, sir.
All right, do find sufficient factual basis to accept your plea. I will adjudge you guilty of this offense. You'll be sentenced to time served,
1 moment, Your Honor.
whatever that may be. I'll impose court costs and a $50 cost of prosecution. That's a total of $273. Would you can you pay that in the next year?
Yes, sir.
All right, finally, I'm going to order that you not return to the Walmart store at 8101 South John Young Parkway in Orlando. If you do go there and the court's made aware of that, you are subject to a contempt citation. That could result in an up to 180-day sentence in the county jail. All right, you'll be
And that
released
was
as to
2
this
days,
case.
Your Honor.
2 days with 2 days credit. Thank you, sir. All right, sir, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
Sir.
And your name is?
Rod Clark.
All right, Mr. Clark, you're here today because you were arrested on charge of petty theft, and you had failed to appear on that. And the bond on that is $150.
Your Honor, the offer is an adjudication of guilt, credit time served, and no return to 10500 West Colonial Drive. I did speak to Mr. Clark. He would like to accept the offer and enter a plea of no contest.
Okay. Is that correct, Mr. Clark? You'd like to enter a plea of no contest to the charge of petty theft?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
All right, you have a plea form there. Did you read over that, understand the rights, and sign it on the bottom?
Yes, sir.
Any questions about the rights on that form?
No, sir.
And,
All right.
And, Your Honor, I would ask, I know the state offered an adjudication. I would ask for a withhold only because he has never been convicted of a petty theft before. He only has driving offenses that he's been convicted of.
So it was only driving before?
Yes. Any objections, state?
Do you have a problem with that?
Actually,
All right, I'll withhold. Okay, so you have signed that plea form. You understand, do you have any questions about the rights? I think you said no. All right, you understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen. All right, I do find sufficient factual basis to accept your plea. I'll withhold adjudication, impose time served, which is
2 days.
2 days in the Orange County Jail. You do have 2 days credit for the time you have previously served. The court cost and a $50 cost of prosecution is a total of $273. Would you, can you pay that over the next year?
Yes, sir.
All right, pay that within a year, and then finally, I'm going to order that you not return to, what is it, 10500 West Colonial Drive in Orlando. If you do return there and the court's made aware of that, you are subject to a contempt citation. The court will take no action on the case he's out on bond on. You still have your other case pending, but I'm not going to revoke that bond since you pled on this one, okay? Okay. Raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. All right, your name, sir?
AJ Brooks.
What was the last name?
Brooks, B-R-O-K-S.
Oh, okay. Hold on.
Joanna Bradley Vaughn is behavior.
All right, well, Mr. Vaughn,
I would ask that he be reset for tomorrow, Your Honor. There is an offer.
okay, we'll reset him for tomorrow. Judge McDonald can handle it. All right, Mr. Brooks, let me go back. I had the wrong file. All right, Mr. Brooks, you're here today because you were arrested on a charge of soliciting without a permit. I have reviewed the charging affidavit, and I do find that there is sufficient probable cause.
Your Honor, the offer is a withhold credit time served. Mr. Brooks would like to enter a plea of no contest.
All right. Is that correct, Mr. Brooks? You'd like to enter a plea of no contest to this charge?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
Yes.
You have, but you understand what's going on here today?
Yes.
You understand what your attorney's job and my job is?
Yes.
All right, you read over your plea form, understood the rights on that, and then signed it on the bottom, is that right?
Yes.
You have any questions about anything on here?
No, sir.
Okay, you understand this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Yes, sir.
All right, I do find sufficient factual basis. I'll withhold adjudication. Sentence to time served,
2 days.
2 days with 2 days credit. Impose court costs. Is this a city case?
Yes, Your
County.
Honor.
$10 filing reimbursement. That's a total of $233. Can you pay that over the next year?
Yes, sir.
All right, pay that over the year. You'll be released as to this case.
Thank you.
No, just for him. Just sign.
Raise your right hand, please. Oh, go ahead. All right, sir, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, and your name is?
David Williams.
All right, Mr. Williams, you're here today because you're arrested on a charge of open container. I've reviewed the charging affidavit, and I do find there's sufficient probable cause.
Your Honor, the offer is a withhold credit time served, and Mr. Williams would like to accept the offer and enter.
All right, Mr. Williams, is that correct? You wish to enter a plea of no contest to the charge?
Yes, sir.
All right, are you under the influence of any drugs or alcohol today? No. Have you suffered from or been treated for any mental illness in the past? Read over your plea form, understood the rights, and signed it on the bottom?
Yes.
Any questions about anything on this form?
No.
Okay, you understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Yes.
All right, I do find sufficient factual basis to accept your plea. I'll withhold adjudication, impose time served,
1 day.
sentence you to 1 day with 1 day credit for time served. Impose court costs of $223, $10 filing reimbursement, a total of $233. Can you pay that over the next 12 months?
Yes.
All right, you'll be released as to this case. All right, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Sir,
Your name?
Willis Taylor.
Sir, you're here today because you were arrested on a charge of open container. I have reviewed the charging affidavit, and I do find sufficient probable cause.
Your Honor, the offer is a withhold credit time served. Mr. Willis would like to enter plea of no contest.
All right, is that correct, Mr. Willis?
Yes,
All right, are you under the influence of any drugs or alcohol today?
no, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
And you read over a plea form, understood the rights, and signed it on the bottom? Right there, yeah, go ahead and sign it now. Do you have any questions about the rights on that form?
No, sir.
All right, you understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Do you understand?
Understand that? Okay. I do find a sufficient factual basis, and I'll withhold adjudication and sentence you to time served.
2 days.
2 days with 2 days credit for time served. That'll be also imposing court costs, $10 filing reimbursements, a total of $233. Did you want to pay for that, or can you pay for it over the next year? All righty, you'll be, just pay for that over the next year, and you'll be released as to this case.
Thank you, sir.
You're welcome. Now we're cooking with gas. Okay. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right. Well, your name, sir?
Joseph Baz.
Mr. Basden, you're here because you're arrested on a warrant for failing to appear on driving while I suspended charge in front of Judge Johnson.
Yes, sir.
Is it time served offer?
I don't have an offer, Your Honor. Would you?
I looked at his driving record. It looks like he has a couple of priors, but from like 2009 or something like that. It's a long time ago.
Okay.
So he could plea. It's not going to habitualize him. He should be fine.
He would like to accept that.
All right. So you wish to enter a plea of no contest to the charge of driving while I suspended, is that right?
Yes, sir.
All right. Are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
And that she's filling out a plea form for you now. You understand the rights on that form?
Yes.
All right. Do you have any questions about any of the rights?
No, sir.
All right. You understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen. You understand?
Yes.
All right. Yeah, it looks like he has two priors. They're actually infractions. They were not, no, they were criminal traffic, but they're from Duval, 2009, 2012, so those won't be used against you. You do understand that driving while I suspended does enhance, and if you get 3 convictions within a 5-year period, you lose your license for 5 years as an habitual traffic offender. You know, this doesn't affect you today. This is only your first in the last 5 years, but if you don't get it fixed and get 2 more before 5 years from today, you're gonna lose your license 5 years. You understand that?
Yes, sir.
All right. I do find sufficient factual basis. I'll judge you guilty. You sentence you to time served.
2 days.
2 days with 2 days credit. Impose court costs, $50 cost of prosecution, total of $273. Can you pay for that within the next year?
Yes, sir.
All righty, you're all set. You'll be released as to this case. Set? Oh, that's right, it's 306, excuse me. 306, it's not 273. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God. All right. Your name?
Pablo Camacho Reyes.
All right. Let's see. There we go. All right, sir, you're here today because you're arrested on a warrant for failing to appear on a no valid driver's license charge. I have reviewed the charging affidavit and your driving record. It does appear that there is sufficient probable cause.
Your Honor, the offers of withhold credit time served. Mr. Camacho would like to enter a plea of no contest.
All right, Mr. Camacho, you wish to enter a plea of no contest then to the charge of no valid driver's license?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No.
Have you suffered from or been treated for any mental illness in the past?
No.
That plea form that you've got there, you understand the rights are on that form and that you're giving up those rights here today?
Yes, sir.
And do you have any questions about the rights?
No.
You understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen. You understand?
I come from Puerto Rico, so.
What's that?
I'm Puerto Rican, so.
That's all right. I have to tell that everybody. I tell whether they're from Ohio, Puerto Rico, wherever, I got to tell everyone. So go ahead and sign that. While he's doing that, I do find that there is sufficient factual basis to accept the plea.
And he has 2
I'll
days.
withhold it, excuse me?
He has 2 days.
Oh, all right, thanks. I'll withhold adjudication, sentence 2 days in the Orange County Jail with 2 days credit for time served, impose court costs and a $50 cost of prosecution. It's a total of $301.
Thank you.
You're welcome.
Okay, it's a total of $301. Can you pay for that over the next year?
Okay, no problem, sir.
All righty, you're all set. Okay. Your name, sir?
DJ Ellis.
All right. Raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes?
Yes, sir.
All righty. Well, Mr. Ellis, you're here today for two matters. First of all, you were arrested on a charge of driving without a valid driver's license. I reviewed the charging affidavit, and there is sufficient probable cause. Bond on that is, it was at $500. I'll reduce that bond to $100. And let's see, we also have, you were also arrested on a charge of resisting an officer without violence. I have reviewed that charging affidavit. We do find sufficient probable cause there. And that would be, bond is set at $500. Did you want to have a public defender on those cases? Want a lawyer?
Actually,
I can appoint a lawyer for you, is the reason I'm asking you.
I'd ask for public defender, but
Yeah, I'll point, they're lawyers. That's what I'm talking about. I'll appoint the public defender on both those cases. Also, it appears that there is a immigration hold on you, so that that will have to get straightened out as well. All right? You're all set. 500, and I reduced the no valid to 100. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, your name, sir?
Rico White.
All right, let me get to that. Mr. White, you're here today because you were arrested on a warrant for failing to appear on a driving while license suspended charge. Let's see. And bond is set in the amount of, come on, $10,000. Let me take a look at this. I guess it's a, well, is this a VOP?
It's the county VOP.
Let me take a look at this. Is it me? Oh, I guess it's failure to, yeah, okay. Bond set in the amount of $10,000. Did you want to have a public defender appointed on that violation of probation? You may, did they already have a PD?
Would you have an offer for me today?
No, it's a violation. You have to see Judge McGinnis on that. All right, good luck. Yeah, I just left it at 10,000. He's failed to like 4 times. So. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Honor.
Your name, sir?
Daniel Allen Bryant, sir.
All right, let's see. Got a couple of cases here. All right, first of all, you're here, you're arrested on a failure to appear on a possession of controlled substance.
Yes, Your Honor.
The bond on that is no bond. And then you also had 2 or 3 cases. A failure to appear on a tampering with evidence, possession of drug paraphernalia. And there's a bond of $2,500 on the tampering and $100 on the possession of drug paraphernalia. And I'll appoint a public defender to represent. Well, did you already have a PD? Yeah, you already had a PD on those cases, didn't you? Yeah, public defender was already appointed, so you already have a lawyer and all of that, okay?
All right.
Good luck. solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God? Yes? All right, your name, sir? What's the last name? Luxon, all right, Luxon Calliston, all right. You're here today because you were arrested for 3 charges: possession of cocaine, possession of cannabis less than 20 grams, and possession of drug paraphernalia. I have reviewed the charging affidavit. I do find sufficient probable cause. Those bonds will be set 1,100 and 100. Did you want to have a public defender appointed, or you want a lawyer? Yes? Want me to appoint a lawyer for you? All right, I'll appoint a lawyer for you. PD appointed.
Your Honor, I know he wasn't able to, you weren't able to reach his emergency contact, but could you guys try again so he can qualify for pretrial? He can't afford it.
Yeah, okay, I'll set bonds, or if he qualifies for PTR, I don't have any objection to that.
Thank you.
Raise your right hand, please. Solemnly swear the testimony you're about to give you the truth, the whole truth, and nothing but the truth to help you God. All right. First of all, you were arrested on a charge of burglary of an occupied dwelling. I have reviewed the charging affidavit. There is sufficient probable cause. Bond is set in the amount of $5,000. And you were also out on bond for a charge of possession of heroin and possession of fentanyl.
Actually, Your Honor, they,
Or was that, yeah, what?
they filed on those charges with, trafficking more than 14 grams of fentanyl, possession of controlled substance with intent to sell, and possession of cocaine.
So that's what it's actually been filed on in that case number?
Yes,
That's the 2020 CF?
yes.
Okay,
10.
I'll revoke those bonds, set no bond. Did one have a public defender appointed to represent you?
No.
I think he has a private attorney on the out on bond.
Oh, do you
I have
have?
a private attorney.
Okay,
right now.
all right. They'll stay in the case then. Hope they don't. We're gonna call it 1 o'clock. What's that? So on the burglary, stay the bond at 5,000, and on the old case, revoke the bonds. No, he said he had a private lawyer. Yeah.
Darrell Fraser refused.
All right, Mr. Frazier, I think it was all right, and I think it's already, he failed to appear on a grand theft charge, and there's currently no bond, so stay it at no bond.
Melanie Gasden, medical.
Let's see. Did you want to? All right, what I'll do is, yeah, I do find probable cause. I'll set bond at $1,000 or PTR if she qualifies. And then you guys can screen her, and hopefully she can, if she qualifies, she can get out. And appoint a public defender. Raise your right hand, please. Solemnly swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, Your Honor.
Your name, sir?
Frank Gonzalez.
All right, Mr. Gonzalez, you're here today because you failed to appear on your possession charge. Bond is set at an amount of $10,000. And what's the detainer? Oh, there's also a hold for you, though, out of Volusia County. Is that what the detainer is?
Yeah, he does have a Volusia County hold, but he's a registered sex offender.
Okay,
That's what that.
all right. And I'll appoint a public, did he already have a public defender? All right, you already had you have a public defender on the case you failed to appear on, so just stay in contact with them. Thank you.
Warner Harris refused.
Okay, yeah, he's got a lot of stuff.
And I will waive the appearance, Your
All
Honor.
right, so starting with 2021 CF 14269, stay the bond, that's on the KPS on that case, which is $1,500. And 2020 CF 6140AO, defendant failed to appear. There is no bond on that. 2020 CF 9309, failure to appear. No bond on both counts. Which one am I missing? 9309, 2020 CF 9309, defendant failed to appear. No bond on both. (9310), 2020 CF 9310, defendant failed to appear. No bond on both. And 2021 CF 9416. Defendant failed to appear. It was a bond amount of $2,500 on that. And that should do it for all of his. All right. Raise your right hand, please. Solemnly swear the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Your name, sir? Your name? Mr. Howard, you're here today because you're arrested on a charge of sexual battery on a child between 12 and 17 by a person over 18 and lewd and lascivious molestation on a victim less than 12 years of age. I have reviewed the charging. This actually was from an arrest warrant, a probable cause warrant.
Your Honor, count 1 is a cap-sex bat, and count 2 is punishable as a life felony. I would ask defendant be held no bond on both of those.
Is sexual battery on a child over 12?
It's under 12.
It
Both of
says
them are under
commits a
12.
sexual battery on a child 12 to 17 by a person over 18. That's count 1, right?
No, it's under 12 by a person over 18.
That's not what it says on the warrant. It says 12 to 17.
Which is, but
And I don't have I'm just looking at the arrest warrant. Looks like it was Judge LeBlanc. It says, commit sexual battery on a child 12 to 17 by a person.
Yeah, it's stating two different charges, because at the top of the warrant, it says count 1, sexual battery on a victim less than 12 years of age.
The affidavit and the actual warrant that was signed. The affidavit says sexual battery on a child 12 to 17 by a person over 18.
well, what I'm looking at says sex bat on a victim less than 12 years of age.
No, so on the top of the warrant, it says sex bat on a victim less than 12.
Yeah.
In the actual
Narrative.
Yeah, that's the only place it says that.
Yep, it actually says sexual.
Huh. Well,
Yeah,
what
but
are-
if
what
you
are-
actually read the affidavit, the abuse started when she was less than 12 years old.
You know, law enforcement needs to be more careful on how they write these things up. It's, that's just inexcusable. The narrative, right at the very end, says capital sexual battery on a victim less than 12. The facts relate to that, but the actual statute that this officer, and these people who do sexual battery, do cap 6 battery cases should be the ones who are not gonna mess this up. I see this stuff all the time in Osceola. I get it, that happens there, but this should not happen in Orange County. This is just inexcusable. Because the statute number that they're referring to is either the incorrect statute number, or they're not asking for it to be charged under that statute. Shoddy work. All right, there'll be no bond on both counts 1 and 2. I'll appoint a public defender to represent you. I'll have a lawyer to represent you. Yes, sir.
I do have an attorney.
You do? So you don't want me to appoint somebody right now? They haven't entered a notice yet. Do you know that they're in the process of doing that?
Her name is Corey Cohen.
That's a he, but there are people, it's a female, that he has a number of attorneys. Okay. I can appoint a public defender for you now, and then if Corey Cohen's office files their notice, they can withdraw, and that way you've got someone in your case right away. Or I can just wait, and then you can just wait till Corey's office enters her notice. The reason I say that is that these are serious charges. I imagine they're probably charging you a large fee. It may fall through. You may not be able to get it so that you hire him, and then as a result, you haven't had a lawyer for however period of time. Yeah, what's that?
He's already hired.
So you already paid him? Okay. He said he had already paid.
Okay, all right, then you're probably gonna, my last day, I'm gonna get in trouble for moving everything out. Because he's a private lawyer, they probably expect me to come at 12 o'clock. Yeah. Oh, well. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Your name?
Heather Johnson.
Mr. Johnson, you're here today because you are arrested for 2 charges, battery, evidencing prejudice, and battery on a uniformed security officer. I have reviewed the charging affidavit. I do find that there's sufficient probable cause. Bond set amount of $3,500 on count 1, $1,500 on count 2. Did you want to have a public defender to represent you? Want a lawyer?
I want one.
Is that?
I want one.
Okay, I'll appoint a public defender to represent you.
Thank you.
35. Just stay it. Yeah. Is it? Yeah, my eyes are bad. All right, that was 25 then. If it was 25. Let me look at what I had here. Oh, yeah, okay. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, your name?
Howard Jones.
All right, Mr. Jones, you're here today because you were arrested on a charge of possession of methamphetamine, and I do find sufficient probable cause. I will set by amount of $1,000 on that. And let's see. You were out on bond on a possession of cocaine case, 2021 CF 15752AL, take no action. I'll leave that in place. So you just have the $1,000 bond. Did you want to have a new public defender appointed on this new charge?
Yes.
You want a lawyer? All right, appoint a public defender.
He has a second case.
Oh, I thought he did. Let me see. Yeah. The misdemeanor?
Yes.
Okay, and in addition, you were charged, arrested for trespass after warning, and I do find sufficient probable cause on that. Bond's $500 on that, and I'll appoint a public defender on that one as well. Okay? You're all set. Raise your right hand, please. Solemnly swear the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Your name?
Tyree Jones.
All right, Mr. Jones, you're here today because you were arrested on several charges. First of all, attempted second-degree murder with a firearm, discharging a firearm in public, and finally possession of a firearm by convicted felon. This was a probable cause warrant. Bond on count 1 is set at $75,000, count 2, 10,000, count 3, 10,000.
Your Honor, my client would like to know if he could get a reduction on count 1. No. His last conviction was in 2016 for robbery, so he hasn't been in trouble for a while, Your Honor.
We had a robbery, and then now the allegation. Let me take a look at the affidavit, because I don't think I read it, since it was just a warrant. No, not this time. Can see what the judge in the case does.
Yes, Your Honor.
Your name, sir? Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Sir.
And your name?
Julian Lamp, sir.
All right, sir, you're here today because you're arrested on a charge of no registration. And also looks like possession of cocaine. I do find sufficient probable cause to, on the possession of cocaine, bond set in the amount of $1,000, and on the no registration, I'll release you on that one, ROR. Okay, and did you want a public defender appointed? Want a lawyer?
Already paid bond on this charge.
You already hired somebody?
Already paid bond on these charges before. I'm just back on the warrant.
Right, well, you got a bond, yeah, but if you bonded and you failed to appear, then that bond goes away. You're gonna have to rebond.
I was in jail. I never got out. I got transported and they just skipped my court.
Well, this possession case doesn't show that you ever bonded or anything. You're Joseph?
No, sir.
Who are you?
I'm Lampkin, sir.
Who?
Lampkin, Napoleon, sir.
What happened to Berlando Joseph? That's not him.
Me too.
Oh, there you go.
And so I'll waive the appearance, Your Honor.
All right, on the no registration, do what I did, $1,000, stay the bond on the possession of cocaine, and ROR on the no registration, say, wait, you don't have to change anything. All right, hold on. All right, Mr. Lampkin, you're here because you failed to appear on your possession of controlled substance and introduction of contraband into a county detention facility. There's no bond on that. And I'll appoint a public defender. Well, it looks like the PD may have withdrawn before. No, Nicole Dickerson, well. She's no longer a lawyer, so you can't use her anymore. So, did you want a public defender?
Yeah, I'll deal with one for right now.
All right, go ahead, hire a private lawyer. Don't worry about Ms. Dickerson, she was disbarred. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. All right, your name, sir?
William Mays.
William Mays, okay. You're here today, Mr. Mays, because you failed to appear on your possession case.
Yes, I'd like to know, when was that issue? What date was that?
All right, let me check for you. The bond on that is $2,500. It looks like it was September 17th of 2021, so
I was incarcerated.
September last year. Okay, well, to speak with your attorney, did you have the public defender already?
Yes.
Yeah. Speak to public defender, they'll take a look at that, all right? Raise your right hand, please. Solemnly swear a testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God? Yes? All right, your name, sir?
John D. Merritt, John Dennis Merritt.
All right, Mr. Merrick, you're here today because you failed to appear. Hang on your charges. That was a possession of cocaine, resisting without violence, possession of drug paraphernalia. And, yeah, that looks like that's it. You failed to appear on those three charges, and the bond is as follows: $2,000 on the possession of cocaine, $1,000 on each of the two additional counts. And I think you already have a public defender.
Talk about the failure to appear.
Doesn't he know?
I'd like to say something.
Okay. Well, unless your lawyer says not to. Looks like you failed to appear in October 25th. There was a status hearing and you didn't go. All right, raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes?
Yes.
Your name?
Ezekiel Ortiz.
All right, sir, you're here today because you were arrested on a probable cause warrant for the charge of aggravated assault with a firearm. Okay, yeah. All right, I'll set bond in the amount of $3,500. You're to have no contact with Javier Narvaez, Narvaez Rodriguez, or his brother Xavier, Xavier, Narvaez Rodriguez. Not possess any weapons or guns, no drugs, no alcohol. And I will appoint a public defender to represent you. Yeah. Raise your right hand, please. Solemnly swear testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Your name, sir?
Isaiah Osias.
Okay. All right, sir, you're here today because you're arrested on a probable cause warrant for the charges of grand theft third degree and grand theft of a motor vehicle, 2 counts. The bond is $500 on each. What is this other stuff? We only have that, but he's got these other things.
He's just here on those, on that
Okay.
case, Your Honor.
The other stuff is at another time. All right, did you want to have a public defender appointed on these grand thefts?
Yes, please.
All right, I'll appoint a public defender to represent you.
Late Bethany, refuse, Your Honor.
All right, Mr. Pentheny is here on a grand theft for failing, he had failed to appear. Bond set of $1,000. All right. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes? All right. Your name, sir?
Mike Santiago Piero.
All right, sir. You're here today because you were arrested on a probable cause warrant for the charge of aggravated assault with a deadly weapon. Bond is set in the amount of $2,500. And hang on just a second. If you do bond out, you are to have no contact with Phyllis Teresi, Phyllis L-I-S, last name Teresi, T-E-R-E-S-I, or Jennifer, Jennyferrer Polanco, Polanco. No contact with them, no return to 3024 South Rio Grande Avenue, the apartments of the Cara West Apartment Club. Don't possess any guns or weapons, and don't possess any drugs or alcohol, all right? Did you want a public defender? Do you want a lawyer? No? All right. Raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Yes?
Yes.
All right. Your name?
Lucida Sanchez.
Okay. All right, Ms. Sanchez, you're here. Okay, let's see. You failed to appear. First of all, you failed to appear on your battery. You had a battery of over 65 years, a person over 65, battery with one prior, attempted battery, and a petty theft. Okay, so this is a competency issue. On that failure to appear, there is no bond. Is PD appointed already in these cases?
Yes.
Yeah, all right. And then in the other case, you failed to appear and you're tampering with physical evidence and resisting an officer without violence charge. And there's no bonds on those as well. Just make a note, it looks like she's already been found incompetent, so someone needs to get with her and figure out what they're gonna do. Okay, thank you, ma'am.
Sean Spiegel, refuse.
Okay, Mr. Spiegel's case. All right, I have reviewed the charging affidavit. I do find sufficient probable cause. Set bond the amount of $1,000. Guess there must be a card tournament or something going on in jail. Everyone's too busy to come see me. Raise your right hand, please. Solemnly swear the testimony I'm about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
And your name?
Andre Williams, sir.
All right, Mr. Williams, you're here today because you were arrested on a probable cause warrant alleging that you did not register as a sex offender as required under the statutes. Bond is set at an amount of $1,000. Would you like a public defender appointed to represent you?
Yes.
All right, I'll appoint a public defender to represent you.
That's it?
Yep, yep. Raise your right hand. Come on. Raise your right hand, please. Solemnly swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right. Your name?
Stephen Williams.
Mr. Williams, you're here today because you're arrested on charge of possession of cocaine and possession of drug paraphernalia. I have reviewed the charging affidavit. There is sufficient probable cause. Bond set in the amount of $1,000 on the possession of cocaine, $100 on the drug paraphernalia.
Open? I don't know. I'm
Your Honor,
never get a little less.
Your Honor, can he
I'm on
qualifies,
disability.
can he get pretrial release?
Yep. If he does qualify. What's that?
He qualifies.
He does?
Yep.
Okay.
Uh-huh, that's what I asked. I said, since he qualifies.
He does?
He does.
All right. Did you want to be, you want a PTR then? Pretrial release instead of a bond?
I don't hear good. I got hit in the head with a box.
Okay.
Go.
Oh, yes.
He said
Yes?
yes.
Yes, sir.
All right, I'll release your
I
pretrial.
just don't hear good. I got hit in the head with a box.
That's fine, no problem. PTR in lieu of bond, and appoint a public defender to represent you.
Any conditions, Your Honor?
No drugs, no alcohol, no weapons, and no guns. Did I say that? Yes. Drugs, alcohol, nothing. They clean.
Yeah, you don't.
Oh, cool. Thank you very much.
All righty.
Nothing further from the fence, Your Honor. May I be excused?
Yes.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.